Welcome to the Contractor Council Podcast.
Hello, everyone, and welcome back to the Contractor Council Podcast with Joshua Irvine. Joshua is a business and tax attorney based in Utah who works with construction and trade companies as outside general counsel, helping them get paid, stay compliant, and build stronger businesses. I'm Sean O'Connor, and today Joshua and I are talking about what to do when work has already been done and payment isn't coming in, and how contractors can protect themselves before it turns into a bigger legal problem than it needs to be. Joshua, good to see you.
Hey, good to see you too, Sean.
I hate not getting paid. I don't know about you, but, it's like, what? What are the early signs? This isn't just, okay, slow payments happen, right? But what are the early signs that it's not just a slow payment and that it's turning into a real problem? What have you seen?
Yeah, and I suppose every relationship's a bit different, but if I'm gonna take a few of the dynamics that I've seen from clients over the years, a number of the yellow flags come with the delayed or the renegotiation of payment terms from the beginning. Hey, I don't really want to do a down payment that big. Hey, I can't really make the next progress payment. Can you give me an extra week? And you might be 20% into the job and they're already trying to adjust payment terms and timelines. That always becomes a big yellow flag. And in hindsight, often it reveals what that relationship's going to be like. Another thing is, frankly, kind of how speculative that work might be. So some of my clients get in and they work with developers on big commercial neighborhoods or projects. But those are always going through ups and downs and bankruptcies and, not even just kind of doing your own due diligence about who your clients are can sometimes be a big problem.
Yeah, the development, there's a major company putting up a new development, new cul-de-sac, and they're doing it on the comm. They're waiting for their they're trying to sell some of these plots or these homes, and we've seen that movie. But I'm curious. You and I'm the contractor. You're my client, and it's very, like you said, it's the first few weeks of the project, and you're coming back with like, hey, could you give me another week? Or maybe it's that very first. I don't want to give you that big of a down payment. What do you do? Oftentimes this is hindsight, but how do you do that in the now, sort of in the moment? What would your advice be to someone? Like, just be more of a hard ass and say no, or what?
Well, from a high level, I because I'm a business owner too. And so it's really easy for me to have these conversations with them as business owners. And I say, look, we've all had that client or that job or that case that we regret. And this might be yours. And so sometimes it's better to walk away from those kind of clients at the very beginning than it is to force it through and to make it work when you knew from the beginning that they weren't going to fit your model. I mean, like before this call, I had a meeting this morning with somebody who admitted within the first 2 minutes of my call with them, hey, we have a client and we're having a problem, and this client really isn't our typical client, but we decided to do the job anyway, and this is the reason why it went off the rails. I'm like, well, the payment, and for them, actually, the payment was part of the problem, and they accepted it anyway, and they worked on it anyway, and then they weren't surprised. They were just simply frustrated that at the end they were now chasing the money.
Yeah, it is interesting. People, it's that old saying when people show you who they are, believe them.
Yeah.
That's sort of more of like a personal relationship thing I've heard in the dating world, right? It's like, believe them. And so, I guess too, one thing to handle that would be, if you're asking me like, hey man, I'd like to do a smaller down payment or what have you. There is some in the moment, like you maybe not say, hey, this is a yellow flag. I watched a podcast about this, but you might be like, my experience tells me that when we're having that kind of a conversation this early in the process, the fit maybe isn't right. And so that's an opportunity to be like, let them tell you, well, no, the reason is I'm waiting on this payment and it's going to be good. I'm not going to, then then you maybe can make more of an informed decision. Or they can be like, okay, well, you got me, and maybe this isn't the right relation. It's a way to like hold your ground without being a jerk about it, I guess, right?
Yeah, and you don't have to feel like you're a jerk. I think sometimes there's a stigma around money and asking for money and billing at a certain rate. I mean, at the end of the day, I represent companies, yes, but I don't see companies as these big evil things, because those companies also support their employees and their families, and they're building and beautifying their community. So, for them to ask what's fair and what's reasonable and what they negotiated, I don't think anything's wrong with it. They shouldn't apologize, but and I'm okay if they want to give discounts occasionally, like you said, maybe there's a reason, but let it be intentional and let that be the agreement up front than it is after I've done all the work and now you're trying to get a haircut on the job.
Yeah, right, right. Okay, so now, a contractor realizes that, hey, payment is not coming in. What's the most common mistake that might make the situation worse?
Well, there's probably two. The first one is getting emotional about it, and then these blasted text message strings, and I've had to see these in court. There's like 12 pages long of like beep 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 beep. Like I'm like, buddy, I really don't think we should show this to the judge. Is not going to go well for us because these are a lot of adjectives. But no, so that's one
Well,
side, the emotional side. And number two is that you just don't really have systems for deciding when is the line to escalate. Like, how long are you going to give them? Are you going to give them 30 days or 45 or 60 or 9 months or 2 years? Hopefully, it's not 2 years, but at some point, you have to make business choices. Where are your lines? You need to train your team to have that system so that you don't have to decide every time. It's just simply, hey guys, it's 60 days, send it to the attorney, let's go to the next step, whatever it is.
yeah, or pursuant to our contract or just our usual policies, it's been 3 months, and so we're pulling the crew from the site. No, it's not personal. This is just the systems that are in this company policy. So like your frontline people have that to lean on as well. That makes sense. Makes sense. Yeah, the personal, they're like the dirty laundry in court. That's never going to go well.
It feels good, but it just doesn't work.
What's your advice in terms of what they should do right away to protect their position before things do escalate?
Well, like with most disputes, is having some kind of open communication and that you've documented these issues along the way, that you've tried to seek a resolution. It might be hindsight depending on how far you are in the job, but making sure that you've protected yourself from a lien, like a construction lien standpoint. Some states require you filing preliminary notices when you start jobs. Some don't. But making sure that you've done these things the right way so that you can protect yourself and leverage things if it really begins to spiral. And I know those are hard conversations, but you just have to do it. You owe it to your employees. You owe it to the other people that rely on your company. It's not just you.
I know. And so there's a real ripple effect there. What would you say, what exactly, needs to be documented at the point that, the you've been working, the work is continued, but, they can still prove that what they're owed, like, you want to be able to prove that, hey, we did this work and you owe us for it. What do they need to document?
Well, number one, obviously, some kind of an invoice that they've tried to send an invoice to that customer. Hopefully, there's some kind of a contract or an agreement about the work, the billing, the scope, etc. And so you send those out just like you would anything else, and they can send it themselves or they can have an attorney do it. Doesn't matter. But to be able to document those things, to clearly outline what those payment, differences are. And as it relates to the invoice, to kind of try to have some good detail in there. I've seen customers receive what I'd call like this, just like flat dollar amount invoice and they're like, I don't even know what this is for, right? Like, give them a little bit of detail so that they can compare their own notes and there's not frustration about feeling like you're hiding something. That sounds silly, but even those couple of things really increases the amount that customers are willing to pay because it's been transparent. And then there's not as much argument about what you're billing for. And there may still be an argument about whether they have the ability to pay you or if they think your work is good, but there's not an issue about what you billed them for.
Right. Yeah. The week of, June, whatever, we did the tiling. Yeah. Makes sense. And in your opinion, what point does it make sense to stop work? How do you stop work without creating more legal or contractual risk?
This is a delicate issue to navigate because most contractors, and in the state of Utah, contractors have obligations with their license. And you can't just walk off a job, hey, there's a big old hole in the front yard. Sorry, good luck. I've heard contractors that are like, I'm going to rip off the roof because they won't pay it. I'm like, don't do that. That's not going to end well. But the first way to do it is obviously to make sure your contract gives you that right, because you don't necessarily have an automatic right that you can just walk off a job in the middle unless the other side agrees to it without risking your license. So the way to do that is to make sure you put in there in your contract a clause that says something like, look, if you're, I don't know, 30 days behind on payments, we have the right to pause work until we're caught up. They might not be willing to give you that right in your contract, right? This is a negotiation at the front. If they're not willing to give you that right, that's a huge flag in my mind, because either they've done it to somebody else or they anticipate cash flow problems and they want you to hold the bag, but keep working,
There's that scenario. I'm wondering too, if can a contractor start to lose legal options if they wait too long to do something about what seems to be delinquent payments, lack of payment?
Yes, I mean they can, but it's probably months and months down the road before that really becomes a reality. So if you're done on the job, for example, you might only have 90 days to file a construction lien or 180 days, right? So it's not going to be something that happens probably while you're still on the job trying to work it out. But the only times I've really seen it blow up for people is kind of back to the emotional response. A lot of contractors take pride in their work and they're offended when a customer thinks that they either sucked at it or they don't deserve all the money that they've billed for. And they take offense to it and then do something emotional like, that's it, screw you, I'm walking off the job. And
I'm taking the roof with me.
yeah, right. I took all the materials, I took my tools, good luck filling in that hole. That's usually when it really becomes a problem. So the way to get around that obviously is to try to control the emotional side, or to have some kind of a legal person or just kind of like a peacemaker come in there and look at the contract and try to mediate it a little bit to see if we can make both sides, still be able to work together and finish up the job.
Yeah, that's great, actually, right there, which is, some people just know they're hotheads, right? I mean, just some people are just, they know it. And like, it's going to get personal, and I'm a craftsman. I take great pride in my work. And there needs to be a thing. And like, if this were my company, I'd be like, okay, so maybe it's at 30 days or whatever. There's a point at which I'm not going to make the call. I'm going to have my attorney, perhaps, right? I mean, lo and behold, here we are. But this idea that, like, if my attorney now makes the call, they've heard from me, right? And like, hey, calling you about the payment, we really got to work this thing out. And then the next call they get is a very friendly attorney saying, hey, I'm calling on behalf of Sean's construction company. Just that starts to, there's no risk of me blowing up over the phone with this client. And then it also, assuming in this case you are being very civil and matter of fact with my non-paying client, that to me seems like, oh, okay. It sends a signal like, I'm on this, I'm paying attention, and we have certain procedures in place.
Yeah. Yep.
What if, right now there's someone out there dealing with unpaid work? Like, ooh, what's the first concrete step you think they should take to protect themselves? Like, what do people need to do?
Well, I think the first thing is obviously to send a bill requesting payment. As silly as that might sound, a lot of people are nervous about sending that bill. And then once that bill is sent, then following it up. And over the course of a few weeks or maybe a couple of months, if you're, depending on your terms, then knowing when to bring in somebody else. I talked about this with my clients a number of times, but when I send out letters requesting, payment for, the contract services, it's not anything probably that they haven't already said themselves several times or a dozen times already. And so they can get frustrated. I'm like, hey guys, I'm sorry, but there's something magical that happens when the attorney puts it on their letterhead and they sign it and send it out that finally gets this ball rolling. And I don't know why it is. I'm sorry that that's just the reality. Sometimes people are waiting to escalate before they take it seriously. But just knowing that is helpful so that they don't get frustrated in the process.
Yeah, that's good advice. Good advice. Yeah, I love that too. Like, how about start by sending the invoice? I mean, I can relate, right? There's a fear, like you already have some sense that this isn't going to land well, which to me says, goes back to our earlier conversation about having good communication, right? Or it's like, oh, I never got approval for this work change, this change order. I hope they remember that they approved this.
Yeah.
Because, like, oh, I didn't know it was going to be another $5,000. Like that's real money,
Right.
Joshua, as always, great to talk to you. We're out of time for today, but I look forward to having you share your insight and wisdom in the future.
Thanks so much for your time.
That's it for today's episode of the Contractor Council Podcast with Joshua Irvine. Thanks for listening. If you're a contractor or business owner and want to make sure your contracts, your systems, your financial processes are set up to protect your work and your bottom line, you can learn more at Josh's website, irvine-legal.com. Don't forget to subscribe to the podcast, maybe leave a review, share an episode with someone in your world. We really appreciate it. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.